This video answers the question, how does data privacy legislation affect identity resolution? Recent updates to data privacy legislation have been instrumental in driving developments in identity resolution. The EU's General Data Protection Regulation, or GDPR, which has been active from May 2018, has become the gold standard for such legislation, forming the template in over 60 other territories worldwide, such as Brazil's General Data Protection Law and the California Consumer Privacy Act. By defining personal data and its uses, GDPR was instrumental in providing a strengthened framework of core principles surrounding data privacy and the use of personal data. New rights for consumers to understand and control the use of and access to their personal data. Lawful processing guidelines dictating when, how, and for how long personal data can be kept and used. Mandatory practices for transparency, governance, and accountability of personal data use, and more significant punishments, including hefty fines, when organizations get things wrong. Such legislation has had an impact in pushing identity resolution solutions to deal with a number of complex issues. Central to new considerations are consumer rights, with identity solutions required to facilitate requests such as anonymization under the right to be forgotten. Solutions must practice privacy by design to deal with the strictures of such legislation, providing necessary mechanisms to benefit both consumer and commercial requirements. And with further changes coming, from additional legislation, for example e-privacy, to the results of legal tests of these legislations, the validity of your identity solution will rest as much on its adaptability to these regulations as on your organization's needs.